The U.S. Court of Appeals for the 5th District ruling that nonviolent drug users have a Second Amendment right. This is a case we've talked about in months past, but a ruling out of the 5th Circuit saying, in short, our history and tradition may support some limits on intoxicated persons' rights to carry a weapon, but it does not justify disarming a sober citizen based exclusively on past drug use. What happened here? What is this case all about? Good morning. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk at 6:12. That's right, bright and early. We do it every morning, 6 to 9, right here. You can follow me anywhere, Bishop on Air on X, formerly known as Twitter, on YouTube, where you can watch the live stream and also see video segments of previous shows. Also, you can follow me on Facebook, where we also live stream. But let's get into this because it's fascinating. We've got so many different cases that people are watching when it comes to laws concerning guns and firearms and how those possibly impact the Second Amendment. So you have, of course, a lot of focus here in Illinois, something we've been looking at practically every day. That's the ban on certain semi-automatic firearms and magazines over certain capacities, with a deadline to register those firearms by January 1st of 2024 or face criminal penalties. So challenges there, we're still waiting. Haven't seen any indication as to when the 7th Circuit Court of Appeals in the federal courts is going to rule on that case that they brought from the Southern District and the Northern District, consolidating several challenges of not just the state's gun and magazine ban, but also local ordinances in Naperville and Cook and Chicago as to banning certain types of weapons. So that case is still pending. We have no indication as to when the 7th Circuit Court of Appeals is actually going to rule on that case. But if you're not familiar with the federal court system, we'll review a bit about the different districts that there are, because what happens in the 7th Circuit, it only impacts the 7th Circuit. What happens in the 1st Circuit only impacts the 1st Circuit, and so on. But that's the federal court, right? We're still waiting on the 7th Circuit Court of Appeals decision on the challenges against Illinois' gun and magazine ban. It's expected whatever happens there, it's going to go to the U.S. Supreme Court. But also on that case, we're still waiting on the Illinois Supreme Court's ruling an opinion on the state-level challenge to Illinois' gun and magazine ban. So that's the latest there. But we've been looking at cases elsewhere throughout the country, not just challenging gun and magazine bans, but other elements. Yesterday, we talked about how the ATF's rule on unfinished frames and receivers being regulated firearms, you had that case go through with an injunction issued, but then the U.S. Supreme Court put a stay on that injunction, meaning that the injunction was essentially reversed while that case continues to play out. And I think it's also important to note here, these are all procedural steps for the issues at hand. For instance, the gun and magazine ban in Illinois, you had a preliminary injunction issued blocking it from taking effect for about 6 days from the Southern District, and that impacted all of Illinois, but the state appealed to the 7th Circuit, and there was a stay issued reversing that injunction, so the law is back in effect. But that was only a temporary thing, while the merits of the case continued. So even if the 7th Circuit Court of Appeals say they deny a preliminary injunction, it's going to go to the U.S. Supreme Court. But the merits of the issue have still yet to be fully litigated. Same thing with the ATF rule. Yet to be fully litigated. Even though the U.S. Supreme Court reversed an injunction blocking the ATF's frame and receiver rule, they still have to deal with the actual merits of the case, which are the arguments saying, the ATF can't do this. They can't just make laws by crafting rules. Same thing goes for Illinois' gun and magazine ban. The preliminary injunction, a stay. What's the appeals court going to do? Whatever the outcome there is, it's likely going to go to the U.S. Supreme Court, but the merits still have to be fully litigated. So just so we understand where we're at in the progress of these cases. Now, this case that we started talking about here out of Louisiana, it's in the 5th Circuit Court of Appeals. And coming back, we'll delve into this case and in particular take a look at all of the different districts that there are across the country. You got the 7th Circuit, which is Illinois, Indiana, Wisconsin, Wisconsin. The Fifth Circuit is Texas, Louisiana, and Mississippi. So we're going to train our focus on the Fifth Circuit Court of Appeals and the decision they released yesterday, essentially saying that nonviolent drug users do have a Second Amendment right. So we'll get to that coming up next here and read some of the ruling and some of the outcome, the progression of that case, and more. But I'd also like to get your phone calls at 217-629-7970. Again, 217-629-7970. That's the phone number here. I'll get that right card up there for those watching online. 217-629-7970. You can sound off live and local. Showing the case, United States of America versus Patrick Darnell Daniels Jr. out of the Fifth Circuit Court of Appeals. Well, the appeals court siding with Mr. Daniels in his challenge of a law that ultimately said, nonviolent drug users don't have Second Amendment rights. Welcome back. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's News and Talk. So let's get into this filing here. And of course, this is for the Fifth Circuit Court of Appeals, which wraps in Texas, Louisiana, and Mississippi. And this case came from Louisiana. So I do want to go through and just read some of this. And this is, of course, before Smith, Higginson, and Willett. The Circuit Judge Jerry Smith is a circuit judge, and they write that, U.S. law bars an individual from possessing a firearm if he is an unlawful, quote-unquote, user of controlled substances. Patrick Daniels is one such, quote-unquote, unlawful user. He admitted to smoking marijuana multiple days per month, but the government presented no evidence that he was intoxicated at the time of his arrest, nor did it identify when he last used marijuana. Still, based on his confession of regular use, a jury convicted Daniels of violating the law. The question is whether Daniels' conviction violates his right to bear arms. The answer depends on whether the law is consistent with the nation's, quote, historical traditions of firearms regulations as found by the U.S. Supreme Court under New York State Rifle and Pistol Association v. Bruin. It is a close and deeply challenged question, he says. So the judge goes on saying throughout American history, laws have regulated the combination of guns and intoxicating substances, but at no point in the 18th or 19th century did the government disarm individuals who used drugs or alcohol at one time from possessing guns at another. A few states banned carrying a firearm while actively under the influence, but those statutes did not emerge until well after the Civil War. It goes on to say that the law, the first federal law of its kind, was not enacted until 1968, nearly 2 centuries after the Second Amendment was adopted. In short, our history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug use, nor do more generalized traditions of disarming dangerous persons support this restriction on nonviolent drug users. As applied to Daniels, then, U.S. law, it violates the Second Amendment. We reverse the judgment of conviction and render dismissal of the indictment. So that's really the case in a nutshell here. And the judge, again, really giving all the background that's needed to get to this point. He provides that in this 40-page ruling, and talking about at no point that night that he was arrested did the DEA administer a drug test or ask Daniels whether he was under the influence, nor did the officers note or testify that he appeared intoxicated. But after Daniels was Mirandized at that station, he admitted that he had smoked marijuana since high school and was still a regular user. When asked how often he smoked, he confirmed he used marijuana approximately 14 days out of a month. So based on his admissions, Daniels was charged with violating U.S. law, which makes it illegal for any person who's an unlawful user or addicted to any controlled substance to possess any firearm. An unlawful user is someone who uses illegal drugs regularly and in some temporal proximity to the gun possession. So obviously, this is something that only impacts the Fifth Circuit, but we've been watching this case in particular because it does raise the question about, this idea of what is a law-abiding citizen? Because Heller and Bruin, those decisions do talk about law-abiding individuals, but what is that definition? Is that include those who may be users of cannabis or may have a proclivity to drinking alcohol in excess? Or is it only those who are, convicted of a violent felony or are adjudicated mentally ill and could be a danger to themselves or others? These are important questions when you really get down to the definitions. So when it comes to this particular law that was at question here in the case out of Louisiana, you have the judge again saying, in short, our history and tradition may support some limits on intoxicated persons' rights to carry, but it does not justify disarming a sober citizen based exclusively on his past drug usage, nor do generalizations and traditions of disarming dangerous persons support this restriction on nonviolent drug users. Now, the defense, the U.S. Department of Justice didn't provide comment when asked about this by some media outlets, but obviously this is an interesting outcome, right? I'd love to hear your thoughts on this. 217-629-7970. Good morning. You're on WMAY.
Hey, morning, Bishop.
Hey.
I wonder. This is going to go back. Did he lie on the federal form to say that, because you have to declare whether or not you use drugs whenever you're trying to get a firearm,
right? And that's something that Hunter Biden faced charges on as well. And
that was going to be my point.
Yeah.
Is this going to set a precedent for dropping the charges of Biden of Hunter because it's nonviolent, and it kind of makes you wonder what's going to happen.
Sure.
If he lied on the form, then that's a felony, and we need to uphold the law. We can't
but
just keep
if lying on that form is only there, if that line on that form is only there because of this U.S. law that the Fifth Circuit Court of Appeals essentially struck down, then does it matter about that particular line on that form? It's a question that I don't have an answer to, and I don't think this has yet been fully litigated, as it only impacts the Fifth Circuit and the Department of Justice. They could either just let this lay and it only impacts the Fifth Circuit, or they could take it all the way to the U.S. Supreme Court and force the issue across the country.
Does that form also violate your Fifth Amendment rights, self-incrimination?
I think there's an argument there for that.
There's so much to unpack on that. You can't just go down one route.
No, and you're absolutely right. And that's why this is such an interesting case, right? We talked about this several months ago when this case first kind of came to prominence. And it's interesting to see that at least the Fifth Circuit Court of Appeals, they got a decision out pretty quick on this. So we'll see what happens if the Department of Justice wants to appeal it and go all the way to the U.S. Supreme Court with this.
You have a good day.
You too. Appreciate it. It is Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. Yeah, I guess I should have started with, hey, Hunter Biden might have an out here. I don't know about those tax charges, though, because that immunity deal didn't quite come together as Hunter Biden wanted it to come together. But what are you going to do? So that's fascinating. But again, we're still waiting on any outcome of the challenge against Illinois' gun and magazine ban, something that we'll definitely be watching closely. It is Springfield's Morning News. I'm Greg Bishop. Follow me anywhere. All right, like, subscribe, hit the notification bell, whatever you got to do. Check it out. Share it. Whatever. All right. Appreciate you guys tuning in. As always, it is Springfield's Morning News. Email me, bishoponair@gmail.com. And you can also check me out on all the social medias. Just search Bishop on Air.